You have the right to remain silent, but we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law
spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, folks, there you go, and welcome back. And joining us now is our friend Kendall Coffey. Oh, okay. You mean we played the theme and there's no Kendall? All right, how unusual. But we'll effort Kendall. I'm sure we'll get him up on the board here in just a second or two. And we have a lot of interesting cases to talk about with Kendall, as is always the case. Not only the conflicting decisions from two courts the other day on Obamacare and the subsidy issue. But we also have a couple of other cases of note. One, a Florida jury has awarded a woman, and you probably heard about this, $23.6 billion. 23.6. No, she didn't win the lottery. There's no such prize in the lottery. $26.5 billion to a widow in a smoking lawsuit. And they claim it was punitive damages. It was the R.J. Reynolds Tobacco Company. She claimed that smoking killed her husband, Michael, in 1996. And she said that the tobacco company was negligent. And now, we'll get to that in a second, but let's welcome in Kendall, who, unfortunately, Kendall, you missed your open, but believe me, we did play it.
Oh, well, thank you. Thank you, Steve.
Good to talk to you again, my friend. How are you?
Catching up with you.
Good.
Everything's good.
Good. All right. Let's talk about these two decisions that came down a couple of days ago. One from the D.C. Circuit on a panel, and the other one, the Fourth Circuit Court. And the D.C. panel said that the Obama subsidies in the Affordable Care Act are illegal. And then just about an hour or two later came the Fourth Circuit opinion saying that no, they are legal. But as a layman, I have a feeling that you're going to tell me the stronger argument may lie with the D.C. panel anyway. But I'm trying to predict here.
Well, here's the way the argument is oriented. The Fourth Circuit, which is headquartered in Virginia, validated the Obama position, saying basically that it just makes more sense that these critical tax subsidies, I say they're critical because the tax subsidies that's provided by the IRS regulation makes paying the premiums much more affordable for the users. So given that perspective, the Fourth Circuit says, well, I think that it only makes sense, and what Congress surely would have intended is that even in states which did not create their own exchanges for health insurance, that if the consumer is using a federal exchange, that's good enough because it shouldn't be different from state to state. And even though the law seems to refer specifically to authorizing these tax subsidies to exchanges established by the state, we're going to read the law based on what we think was Congress's intent and find that even if it is a state that doesn't have its own exchange, if people are using a federal exchange, that's tantamount to a state exchange. So sounds technical, but that's the heart of the argument. What the D.C. Circuit said is, wait a minute, plain language is plain language is plain language. And the law says that the tax subsidy, these tax credits that are so important, which most would acknowledge are important to this plan going forward, the law is real clear. It says an exchange established by the state.
Yeah.
Doesn't say a federal exchange. So you don't even get to the question of what the agency, in this case the IRS, might think is a good idea. You don't even get to the point of speculating about what Congress intended if the language of a statute is plain, clear, and unambiguous. So that's the heart of the decision. The D.C. Circuit says an exchange established by the state is not a federal exchange. The Fourth Circuit says that the language, the operative language, an exchange established by the state, that we're going to construe that to mean an exchange that's established federally. So that's the dispute. That's the discussion. What will this Supreme Court do? They tend to go with a plain language that's enacted by Congress rather than put in their own purposes, their own view of how the language should be interpreted. If Congress says an exchange established by the state, that's, if you're a betting man or woman, you're thinking that that's the way the Supreme Court's going to go on this.
Yeah, and because of the contradictory rulings, is that expedited to the Supreme Court, or will I read where the government is asking, or the Obama administration is asking for the entire D.C. Circuit to weigh in? Would that be the next step?
Well, that could slow it down, I'm sure, from the standpoint of basically the whole country that's affected by this saying. The sooner it gets to the Supreme Court, the better. The Obama administration wants to take a shot at getting all of the members of the D.C. Circuit to weigh in on it. That's going to slow it down. Sooner or later, though, this is going to get to the U.S. Supreme Court. And as I say, the language, I just ask you or ask your listeners, if the language says exchange established by the state, we're referring to these insurance exchanges for health care purposes, does that really include an exchange established by the federal government?
Not when there's two separate exchanges, if you will. Not when the Fed does establish some and the state establishes other. I don't see how it does, but it will be interesting to see. I loved your analysis. All right, let me ask you about this execution in Arizona, where the Tom Horn, I'm sorry, that's the Attorney General, where the man who 25 years ago committed such a heinous murder was put to death, and now there are witnesses who said that he suffered for 2 hours. He was really sweating and this and that. And then I heard from a witness who appeared on CNN who said this is all baloney. He was snoring for most of the time, so he was sleeping until the time he died. And the reason I bring this up is because you know that the anti-death penalty people are going to use this as another example in their effort to try to call it cruel and unusual punishment. So how important is what we've heard from some witnesses about this particular execution?
Well, I don't think it's going to change anything in the constitutional sense. I don't think the Supreme Court is all of a sudden going to get meaningfully involved in terms of how executions are conducted. I think that states, a number of different states, where they're aware of what appears to be just some real problems with the manner of execution. Typically, state leaders want to reexamine it and make sure that the process is done the way it's supposed to be done, which is inevitably there is pain associated with putting someone to death, but it's not supposed to be needless pain. It's not supposed to be extended pain. So I think, the governor, Jan Brewer, has said she wants to have this examined. Jeb Bush did something similar some years ago in Florida, and that's the goal of the system, to continue with enforcing the law, not to inflict needless pain. But, at the end of the day, nobody really knows, Steve, whether there's actually this kind of pain involved or not. You simply can't observe and know for sure what's happening. Right. The other irony is, the whole concept of lethal injection was that some folks thought it was a more humane way of putting to death condemned inmates. Some states may go back to electrocution because there really were not constitutional problems with that. And if the states decide that there's just going to be extra litigation, extra contention, extra delays in having the systems that the voters of the state have chosen to pursue fully implemented, then some states may go back to death by electrocution.
Yeah, the electric chair. Very interesting. All right, now in your neck of the woods, Kendall, Florida jury, $23.6 billion to the widow of a man who died, his wife says, from smoking. He died of lung cancer when he was 36. I mean, just on if that's all I knew, I would say this is insane. Because I don't care what you're claiming, I don't care what the evidence, how could you not know, especially the guy died in 1996, how could you not know smoking was bad for you?
Well, and the trial lawyer's expression is it's a runaway jury, that something happened in that courtroom that caused the jury to get, so worked up, so concerned, so passionate about it that they come up with a number that is certainly not going to stand. It's going to be drastically reduced. And ironically, instead of delivering justice and compensation to the family of the decedent, this will turn this case into years of litigation and years of delay before there's any resolution, unless again the plaintiff's lawyer and the tobacco company reach a resolution. But this is why they call it a runaway jury. They've just departed from the rule of law and apparently just let their reactions and their emotions prevail.
Yeah, I mean, $26.3 billion or 23.6, either way, it's just it's outrageous. Anyway, and of course we feel bad that the gentleman died. We want to make that clear. Kendall, always great talking to you, sir. Thank you very, very much.
Okay, Steve, thanks for including me today.
My pleasure and honor. Kendall Coffey, ladies and gentlemen, spinning the law, as we try to do whenever we can, at least once a week with Kendall. Very important issues. And this, runaway jury. Yes, that's a perfect description. We're talking about the guy died in 1996. If I could read right, it might be 1996. He started smoking when he was 13, and he died at the age of 36. So what could I say? What could I say? Feel bad the guy died, but you can't tell me that he didn't know that it was wrong to start smoking and it was wrong to smoke. And runaway jury. That's all I could say. All right, up next, folks, a real estate attorney and lawyer and director of the Carnegie Group. Why am I having tongue-tied? Shari Olson will talk about Dodd-Frank's anniversary.